We have some breaking news this afternoon as the Federal Court of Canada just ruled that the invocation of the Emergency Measures Act was ultra-virus. It was an abuse of power and unconstitutional.
Do you know what time it is?
It's time to get into it. Now, this is not what I expected to see this afternoon as headlines began to make their way across the country. Even the CBC's headline read as follows: Federal government decision to invoke the Emergencies Act against convoy protest was unreasonable, court has ruled. Now, it shouldn't surprise anyone that the Liberal government has already come out and stated that they will be appealing the decision. Of course, they're going to do so, as this will result in a huge ripple effect of people who will be suing the government, as well as class action lawsuits, because it's now been determined that they have suspended Canadian civil liberties, and it was everything but justified. The court orders that the respondent's motion for an order striking the application for judicial review is granted, in part of the court exercises its discretion to determine the matter, notwithstanding that it is moot in the view of revocation and the proclamation and termination of the associated regulations and order. The applicants, Jeremiah Jost and Harold Risto, lack standing and their applications for judicial review are dismissed. The applications, Edward Cornell and Vincent Gerkes, have directed standing and their applications are granted in part. It is declared that the decision to issue the proclamation and the associated regulations and order was unreasonable and ultra-virus, the Emergency Act. It is declared that the regulations infringed Section 2B of the Charter and declared that an order infringed Section 8 of the Charter and that neither infringement was justified under Section 1. The applicants, Edward Cornell and Vincent Gerkes, are awarded cost of the hearing. The respondent and Messrs. Cornell and Gerkes may make a joint submission on reasonable cost award for the hearing, including disbursements, and in the absence of an agreement as to cost, the parties have 30 days from the date of the receipt of this judgment to submit written representations not exceeding 5 pages in length for the courts to determine an appropriate award. The timing of this is impeccable, as all the Liberals are gone away together at a Liberal cabinet retreat. So who do you think has to answer for this? Do you think Justin came out himself to face questions? Of course not. Why wouldn't he send the girl, Deputy Prime Minister, who's running the show? We all know that, Chrystia Freeland. Here's what she had to say.
The fact that you acted, it took issue with how you acted and how you wrote the regulations you did, including in that PCO memo. There's a warning that the decisions you're taking and how you're writing them were open to constitutional challenge. Looking back, was there a necessary steps you had to take to minimize the constitutional impact of these regulations? And did you do a good job of respecting Canadian civil liberties in writing those regulations? Last question.
Look, I truly do not want to minimize the fact that we took these decisions with a heavy heart. This was not a situation we wanted to find ourselves in, and these were not actions we took with any satisfaction or relish. This was, however, and I want people to remember that, an extremely tense time. The safety of individual Canadians was under real threat, as Minister LeBlanc has pointed out. Our national security was under real threat, our national security, including our economic security. That was the reality of that moment. We explored many, many avenues to bring this to an end. This was an option of the last resort. We believed at the time that it was absolutely necessary for us to act, and for us to act in a way that minimized the physical danger to all Canadians. That was really important to us. We believed we were doing something necessary and something legal at the time. That was our belief then. That was our belief as we testified at length to Chief Justice Rouleau. That continues to be my belief today. As our Minister of Justice has said, we will, confident in that belief, be appealing this decision.
I'm sure everyone remembers during the Public Order Emergency Commission that former Public Safety Minister Marco Mendicino was aware that CSIS had come to the conclusion that the legal threshold under Section 2 of the CSIS Act had not been met as it needed to be to invoke the Emergency Measures Act. Have a look at this clip.
What is the date of this note?
I'm afraid I don't know.
Well, look, leaving that aside, yes,
It says it's before the speech Monday morning, which is the date that they announced the invocation. That might assist.
Okay. Yes, I was aware that CSIS had concluded that Section 2 under the CSIS Act was not met. I was aware of that fact.
Thank you.
It's nice to see all of this come out in the wash after everything this entire country has been through together. For nearly 2 years now, the liberal regime's controlled media has worked against the people. What do you think will happen from here? This should set a much higher precedent for invoking the EMA in the future. It should be a lot of potential lawsuits coming from people who were either defamed or had their bank accounts frozen or were illegally detained. Please like, share, and comment, and be sure to subscribe to my channel for more content like this.